Hello, in the next few narrations, we're going to focus on co-ownership. During our focus on co-ownership, the following study outcomes will be addressed. Define co-ownership and distinguish between bound and free co-ownership. Define and explain the undivided co-ownership share vis-a-vis the co-owned property. Explain the rights and duties that co-owners have in the commonly owned property and in the undivided co-ownership share. Identify and explain unreasonable use of the commonly owned property. Explain the maxim communium est mater exarum and provide guidance to free co-owners about the most appropriate remedy in relevant circumstances. Understand how co-ownership principles are applied where the Subdivision of Agricultural Land Act finds application. Now let's turn to the concept or definition of co-ownership. Co-ownership, also known as joint ownership, is the ownership that vests in several persons in undivided shares. In other words, it refers to the ownership that allows a thing to be owned by more than one person at the same time in undivided co-ownership shares. This means that in terms of co-ownership, each co-owner has the right to a share in the entire thing. Now, in common law, there are two types or subcategories of co-ownership which are distinguished based on how the co-ownership came to existence. The two subcategories of co-ownership are bound co-ownership and free co-ownership. As mentioned earlier, the distinction between these two categories of co-ownership lies in how the co-ownership came into being or existence. More specifically, whether the co-ownership came into being as a result of a separate underlying relationship. With bound co-ownership, a separate underlying relationship is the basis of co-ownership. While with free co-ownership, there is no underlying relationship binding the co-owners, meaning it is only the co-ownership agreement that makes the persons co-owners. Examples of where separate underlying agreements gives rise to the co-ownership are where parties entered into a partnership agreement and where parties entered into a marriage in community of property. Co-ownership is an automatic consequence and automatically applies to partnership and marriage in community of property. Whereas co-ownership that arises as a result of a co-ownership agreement alone comes into existence based on the co-ownership agreement and no separate underlying agreement, as in the case of bound co-ownership. The implications of this absence and presence of an underlying agreement can be described as follows. In terms of free co-ownership, co-owners can alienate and burden the undivided share unilaterally. Please note that here we are not referring to burdening or alienating the co-owned property or thing. Instead, this implication relates to burdening and alienation of specifically the co-owner's undivided co-ownership shares. We will look at the concept of undivided shares in more detail in the next slide. In addition, in terms of free co-ownership, co-owners can terminate co-ownership unilaterally, meaning without the consent of the other co-owners. The presence of a separate underlying agreement in the context of bound co-ownership has the following implications for bound co-ownership. Bound co-owners cannot burden or alienate undivided co-ownership shares while the separate underlying relationship exists. Again, this implication affects the co-ownership shares, not the commonly owned property. Also, bound co-owners cannot terminate the co-ownership unilaterally while the underlying legal relationship still exists. In the remainder of the narration, we will be focusing on and elaborating on free co-ownership. Since you have already encountered an example of bound co-ownership in the law of persons and family, and since you will be encountering another example of bound co-ownership when you get to the law of succession. There are two important elements or concepts to a co-ownership which should not be confused and should be kept separate conceptually in the context of free co-ownership. These are the undivided shares in the co-owned property, communium pro indivisio, which may be equal or not equal. And secondly, the co-owned property, which is the thing that the co-owners own in undivided co-ownership shares. Regarding the undivided co-ownership shares, an undivided co-ownership share reflects a co-owner's interest in the co-owned property and would usually be equal to the co-owner's contribution to the purchase price of the co-owned property, unless agreed otherwise. The concept of an undivided share in the co-owned property encapsulates the notion that the co-owned property may not be divided for the duration of the co-ownership, and secondly, that individual co-owners cannot out of own accord burden or alienate the co-owned property without the consent of the owners or without the consent of the other co-owners. In other words, the concept of undivided co-ownership shares has a direct impact on what co-owners can and cannot do with a co-owned property. Also, the concept of undivided co-ownership shares gives rise to certain rights and obligations, specifically with regard to the undivided shares which we referred to in the previous slide, which should not be confused with the rights and duties or obligations that co-owners have with regard to the co-owned property. What is meant with the notion that the undivided co-ownership shares can be equal or unequal is the following. Please consider this illustration. Person A, Person B, and Person C are all co-owners of a farm. As you can see on the illustration, Person A has a 50% undivided co-ownership share in the farm, Person B has a 30% undivided co-ownership share in the farm, and Person C has a 20% undivided co-ownership share in the farm. Together, it makes up 100% shares in the farm. What is meant with the shares being able to be equal or unequal is the fact that Person A and Person B and Person C's shares does not have to be the same percentage, although it can. For instance, if Person A had 50% and Person B also had 50% shares in the farm, then their shares would have been equal. But that would mean that Person C would not be a co-owner anymore. So the idea with the shares that can be equal or unequal is to just illustrate or to let you know that the shares do not have to be equal. Regarding the co-owned property or co-owned thing, the co-owned thing refers to the property over which the co-owners have co-ownership shares. Things that can be owned by the co-owners can be divisible or indivisible. The divisibility of things in the context of ownership becomes important when considering the termination of co-ownership. We will look at this when we get to co-ownership remedies. Please refer back to your self-study notes on the classification of things according to their divisibility and indivisibility. Briefly, divisible things are things that can be divided into smaller components without losing their nature and function and without the components losing their proportionate value. Meaning, divisible things retains their nature, function, and value when divided, while indivisible things loses their nature, value, and function when divided, such as a chair or a cup. Indivisibility can be determined by the physical impossibility to divide the thing or by law as legislation that makes a thing indivisible or prescribes certain procedures before something may be divisible. In the context of co-ownership, The Subdivision of Agricultural Land Act, which refers to Act 70 of 1970, plays a role when thinking about the divisibility of agricultural land under free co-ownership, specifically when the co-owners look to terminate the co-ownership and subdivide the co-owned agricultural land. We will have a look at this when we get to co-ownership remedies. In the previous slides, we have indicated that free co-owners own the thing or property in undivided co-ownership shares. This means that they have to exercise their entitlements as co-owners jointly. And in this regard, co-owners have certain rights and obligations with regard to the co-owned property, but also with regard to their undivided shares in the property. These rights and obligations pertain to their ownership entitlements. We now turn to look at these rights and obligations or duties of co-owners in specifically the co-owned property or thing. In terms of the co-owner's right to alienate and encumber the co-owned property, a co-owner can alienate or encumber the co-owned property, meaning burden the property with limited real rights such as servitude or real security rights, without the consent of the other co-owners. With regard to the co-owner's entitlement to use the co-owned property, co-owners are entitled to use and enjoy the co-owned property. Co-owners can agree in a use agreement that will form part of the co-ownership agreement what the property can and cannot be used for. However, a co-owner has to use the thing or the property proportionate to the size of his or her co-ownership share. Co-owners are required to use the co-owned property in a reasonable manner and not in an unreasonable manner. Unreasonable use has certain consequences and triggers certain remedies of the other co-owners who are negatively impacted by the unreasonable use of the one co-owner. Unreasonable use is present where the co-owner exercises entitlements to the prejudice of the other co-owner's rights. In other words, it refers to use that is detrimental to the co-owner's rights in the co-owned property. In this regard, let us have a look at the prescribed case of Erasmus versus Afrikaner. So basically, the Erasmus versus Afrikaner case is authority for what would constitute unreasonable use and what would not constitute unreasonable use. Please make sure that you read the case and follow the court's ratio so that if you do get a question similar to this one, you know how to approach it. So furthermore, specific manifestations of unreasonable use that are detrimental can be described as follows. Firstly, where a co-owner's use of the property is disproportionate to his or her undivided co-ownership share. Secondly, where the use of a co-owner is inconsistent with the use for which the property is destined to be used or contrary to the agreed upon use. Please see footnote 109 in the prescribed textbook and footnote 17 in the online alternative textbook of Silberberg and Schoeman for examples of use that was unreasonable since the use did not align with the agreed upon use of the property. And thirdly, where the co-owner unilaterally grants rights to third parties without the consent of the other owners. In this regard, let us have a brief look at what happened in the Pretorius versus Neft case. Unilaterally granting use rights to third parties, which then, while also the co-owner is using the property, him or herself, inevitably leads to unreasonable use because it's an imposition of an additional co-owner in the co-ownership relationship together with disproportionate use. So that would constitute unreasonable use that would meet the second requirement of an interdict. All right. So then let's move on to the entitlement to profit, income, and fruit of the co-owned property. So the general rule is that the co-owners are entitled to an equal share of any profit, fruit, or income made from the property proportionate to their undivided share, even where one co-owner labored alone. Also, I want to refer you back to the obiter remarks that were made in the Erasmus case regarding the profits that can be shared. And also, the co-owners can, however, in the co-ownership agreement, agree or decide that a co-owner who labored alone to make the profit and who uses the property proportionate to his or her undivided share may keep the profit made, meaning such co-owner does not have to share the profit with the other co-owners. However, where this co-owner fails to use the property proportionally, meaning the co-owner's use is not proportionate, so it's unreasonable, he or she must share the profit with the other co-owners, irrespective of this agreement. And this was confirmed in the Sauerman versus Schultz case. Co-owners also have the obligation to maintain the property and to contribute to the expenses and losses incurred in terms of the property. In this regard, the general rule is that all co-owners are obliged to contribute to the maintenance and expenses regarding the property. Each co-owner's contribution to maintenance, expenses, and losses must be proportionate to their undivided shares. The obligation pertains only to necessary expenses regarding the property for the upkeep and conservation thereof, and all other expenses that the co-owners agreed upon that will be shared proportionately. In terms of useful and luxurious expenses expended on the property that the co-owners did not agree to contribute to, there will be no obligation on the co-owners to contribute unless it is necessary expenses. To answer the question as to what would constitute necessary, useful, and luxurious expenses, please refer back to the distinction of and tests for necessary expenses, useful expenses, and luxurious expenses set out and explained in the lectures on liens or retention rights under the study unit of real security. You need to be able to know and apply these tests here in this context and know in which circumstances a co-owner will be able to contribute towards expenses incurred in terms of the co-owned property. Also, see the obiter remarks made by the court in the Erasmus case about the applicant's liability proportionate to his or her co-ownership share regarding the expenses incurred for the mining of the coal. Now, there's also a right to veto that co-owners have. Now, with regard to the right to veto, please note the following. A group of minority dissenting co-owners can veto decisions of the majority. To illustrate an example of this right to veto and a co-owner trying to enforce this right to veto, although in this case this enforcement failed, we saw this also in the case of Erasmus versus Afrikaner, where the applicant tried to argue that if the other co-owner wanted to mine the coal, he first had to obtain consent from him as the other co-owner before he can use and enjoy the property, so mine the coal. And in terms of this argument, the applicant tried to say that he has a veto right where his consent was not required or asked for or obtained. He can veto the use and enjoyment of the other co-owner. This argument unfortunately failed in the Erasmus case. Why? Because no co-owner has a veto right over another co-owner using and enjoying the property as one would expect a person to use and enjoy such property. And that is really what the court held. Okay. Now, the right to veto pertains to decisions regarding the use of the property. This means that decisions regarding the use of the property is not necessarily binding on the minority due to this veto right. What does this practically mean? Once a decision is vetoed, the minority dissenting co-owners can decide to terminate the co-ownership by instituting the appropriate remedy for this, or test the reasonableness of the proposed new use, by also instituting the appropriate remedy for this. And we will look at remedies in the next part. Okay, just also to add on to this idea of vetoing use. As we've seen in the Erasmus versus Afrikaner case, where it's the normal use or the agreed upon use, or the logical use for an object or property, then a right to veto will not exist in that context. Only when the use is changed, for instance, or the type of use that a co-owner wants to employ is not suitable for the property, then a co-owner can veto this, or use this right to veto this new proposed use. All right.